Going to tell you on the copies there, I want to use those for the board, so don't write on them. Okay. So I have a meeting tonight with the board committee. All right, man, you're late again.
Alrighty, everybody, I think we'll go ahead and get started. As we kick off this first part, we're going to definitely have time for questions, but if everybody could mute unless they're actually asking a question, that way we won't hear you making rude comments about us and we won't have hurt feelings. We'll get the ambient noise and all that. Just so y'all know, we are recording and we'll post the video to the policy service page down below where you saw all the updates. That way, if you've got, like I heard Alan say, he had a board committee tonight. If you've got committee members that really are invested in hearing this, they can log in or you can go back or whatnot. You guys have paid for this, so we would ask that you don't share that link with the whole wide world, but you know, we're not going to hunt you down and kill your children or anything like that. So when we started doing policy updates this year, we said to each other, oh gosh, we don't have very much this year. The unicameral didn't really do much to us. And as we started working through the service, we saw more and more stuff, and it was enough that when Amy Melander called and yelled at me for giving her too many policy updates, I knew that that we'd gone too far. But I think we've carved this down to the fewest number of problems for you to solve. We tried to keep this packet at a workable amount. So what we're going to do is we're going to kind of run through the policies in the order that they're in that cover memo. After we talk about each policy, we'll stop and give questions. If you have questions about that policy, go ahead and unmute and ask the question at that point in time. And then at the end, we'll leave time for questions. We're going to finish up with transgender, so I assume there'll be a lot of conversation about that anyway. But if you have overall questions or questions that you don't get asked as we go through, just ask them at the end. All righty? Everybody give me some nonverbal cue. Yes, okay. So you're starting. No, I'm starting. Okay, the first thing we sent out in the policy memo is revisions to policy 2005 and 2014. This deals with conflict of interest for board members. The statutes, 4015
in 2000
and 2005. What did I say?
2000.
Oh, 2005, 4015. The statutes in Nebraska allow for school board members to serve as employees of the district so long as they aren't teachers. And so you could, if you wanted to, allow your board members to work as substitutes, custodians, cooks, bus drivers, et cetera, et cetera, et cetera. In our experience, we don't love that. We think that that creates all kinds of weird problems with employing board members. But we have some school boards that say to us, well, we won't have any bus drivers if we don't have a board member do it. Over the years, the various updates to 2005 and 4015, I'm not sure everybody had everything updated at the same time so that these two policies match. So here's what we did. We revised policy 2015, so 2005, so that it no longer references board member employment specifically, yay or nay. What it does is it tells board members if you want to be an employee of the school board, go and check with policy 4015 to see if that's okay. That way we don't have the problem of the potential of you adopting one policy in one place that says a board member can work for the district, and in another place saying a board member cannot work for the district under any circumstances. And then when we were doing this update in 4015, it will shock all of you already 4 minutes into this webinar. You may have realized that I transpose numbers, or numbers aren't my thing. So in policy 4015, there was just a typographical error, the statutory reference. I'd flipped two of the numbers. And so we fixed that when we went through 4015. I think all of you, even if you've been very diligent in updating your policies, I think this is one that everybody should take a look at and probably adopt the updated version. 2005 is a policy that we've updated several times over the years, and this will be for sure the most current and most accurate version. And so I think we would encourage everybody to adopt this policy.
And just real quick too, if you're somebody who it was just an update subscriber, and so you haven't necessarily adopted our policy 2005 or 4015 at any point, we encourage you to check, obviously, with wherever you have listed the board member employment information if you don't have these policies. So some are full policy for your subscribers that are listening, and some are update subscribers. So we're going to talk generally about our full policy service policies, but obviously check and see what yours say, because you could create the same problem by adopting this and not also looking at what you have.
All right, we'll pause. If you have questions that you want to ask out loud, you can unmute and ask the question now. We also, Bobby and I, have our email up, so if you don't want to ask in front of everybody, you want to shoot us an email, we'll answer email questions as well. So anybody have questions about 2005 or 4015?
Karen, this is Mark.
Yeah. Hey, Mark.
Hi, 4015 policy. You talked there about a conflict of interest. If a board member is an employee, they need to terminate. So how does that match with 2005?
Well, hold on just a second,
Mark, you're super faint, so.
Yeah, we can't hear you at all, Mark.
Ask again.
Okay, and looking at policy 4015,
There we
you
go.
talk about there that a board member, if they're employed, they have to either relinquish board membership. But in 2005, you talked just the opposite, it appears to me.
There's two versions of 4015. One says that if you want to work for the school district, you have to relinquish board membership. The other one says you can work for the school district and remain on the school board as long as you're not employed by a teacher.
Okay. All right, well, I need to find that second one then.
If you go back to the where we had posted the updates, Mark, you'll see two versions of 4015. One says allowing non-certified and one says not allowing. And so whichever we basically just provided both so that you don't have to come up with the difference on your own. So whichever direction you're going.
If we go with the latter, then how does that affect 2005?
Well, that's what the revision we made to 2005 is to make it so that regardless of which version of 4015 you adopt, you won't have to fiddle with 2005.
Okay.
But that would be a change, depending on which version of 2005 you have, that will be a change from what you had before. And so the focus there is under policy 2005 sub 2A. It says board members who enter into employment contracts with the school district must comply with policy 4015. Then when you go to 4015, it's either going to say, yes, you can work for us, or no, you have to resign as a board member before you can work for us. Does that make sense?
Yes, thank you.
Okay, other questions? Awesome, okay.
All right, the next one is policy 2015. This is for student board members. We had locked you guys into choosing the student board members at the May meeting. That's not required by statute, so we've taken that out. I mean, you can leave it as May if you want to, but it's not required. You can actually appoint them in any month. We also had limited things down to the board member being a senior. That is one of the options, but that's not a requirement that they be a senior, so we've taken that out. So what you have now, anything that's in there that's a requirement in the policy is required by the statute. Otherwise, now you just have more flexibility when you appoint them and who you appoint.
Any questions about 2015? All right. Seeing none, and if we skip past one, Alan, I can't tell if you're raising your hand or if you're just giving an animated dissertation about the policy, but if we skip past these too quickly, just drop either Karen or I an email or send one to ksb@ksbschoollaw.com, and we'll make sure to come back to it. Otherwise, we're going to move on to 3014. 3014 is a pretty complicated set of changes, and I'm going to try to go through them as quickly as I can. So if you have questions, I'm guessing you may. So certainly, like I said, drop us an email or let us know when I'm done discussing it. But basically what we did with 3014, because 3014 covers such a complicated area in the law, which is allowing use of your facilities. So the first major change that we made is we added a new section to the beginning called use of specific facilities by application and agreement. Basically, there is a difference, I think, in most schools between when you open up your weight room to patrons to use on a regular basis and when you have, a church group that wants to use your gym for a funeral service. There are a lot of, kind of one-time unique sort of uses and then the regular sort of uses. Our policy previously didn't really account for that. And so what we've tried to do is, because we get a lot of questions about, well, do you have an agreement that we can use when somebody wants to use our weight room or our track? That's different than the application and agreement that most schools use when somebody wants to rent your facilities to host whatever, like I said, a funeral, something to that extent. So the first thing we did in adding that top section, what is now section 1 of the updated 3014, is to account for these regular uses. So somebody makes one application at the beginning of the year and they can use whatever you've clarified in there as the facilities that you open to patrons. If you don't do that, if patrons can't use your track and your weight room whenever they want, then that would be something that you'd have to talk to your board about, and then you could delete that entire provision. But I think most schools have that dual use. So what we've done, if you look kind of further down toward the list in the list that we put together, is we've got 2 facility use applications. One is called regular facility use waiver, release, and agreement, because in that one we've included things like if you hurt yourself by trying to squat 500 pounds, you should have known that that's a risk when you came in to use the weight room. So we've got a lot of those typical waivers that you have in your weight room policies, for example, and weight room agreements in that one. So that's the one that we've intended to apply for these regular uses, your weight room, your track. The other one is the general facility use application. That's when the church group wants to rent your gym for a funeral. That's when an art fair wants to rent your gym for a show. That's when whoever else it might be wants to come and use your facilities, but they're not doing it on sort of that regular basis. So of course there's a little overlap. I've already gotten the question, well, what about if we have somebody who hosts a monthly meeting at our school? In that case, I think they would use the general facility use application because, for example, you may charge for that use, you may not, but that's the idea in that distinction. So if you have questions about that, that's one of the main changes to this policy. And then we've got the 2 proposed agreements for you to take a look at too, which would be consistent with those provisions. The second main change that we have is prohibiting commercial uses. And so if you look at section 2 of the updated policy, it says general facility use guidelines. School facilities may not be used for personal profit or other commercial purposes. That may or may not be consistent with your practice. So this is going to be one where you definitely are going to want to talk it through with the board. What we have received a lot of questions recently, from multiple schools, is we've got somebody, for example, who wants to come in every Saturday and host their own bake sale. So they want to come in and sell things at our school every Saturday morning and basically have their own little craft fair. And one school, it started to turn into like a farmer's market where you had several people that would show up at the school to sell their stuff in the gym. That is something your board can authorize, but what we encourage you to do is to think about that. Other schools have said, for example, we don't want somebody coming in and running a for-profit weight training class using our facilities where we're basically covering all their overhead. So we've had several schools who have had a personal trainer in town decide, hey, I'll teach yoga classes or I'll teach weight training classes if you just come into the school every morning at 6 a.m. and pay me $100 a month. So the board in a couple of those cases didn't like that somebody was using the equipment that the taxpayers bought for their own personal profit. So what I suggest is just you have that conversation with your board and figure out what they want. The policy as written, if you look at sub 2B, says that the school facilities may not be used for commercial purposes, other than our booster clubs, the PTO, folks that are raising money specifically for students. So just to draw your attention to that one. The third major change, which we're not going to spend a lot of time on, is we've redefined the types of groups that use your facilities. We used to have 2, sometimes 3 different groups, but what we've basically got now is a grouping of 4, because under the cases which have come out from the Supreme Court, that provides you with the best legal protection. So the first is a curriculum-related student group. Those are obviously things that are, under the school's control for the school's classes or the school's programming. Then there's extracurricular student groups. So for example, FFA might qualify as a curriculum-related student group, and the basketball team might be an extracurricular student group. Then we've got non-curriculum-related student groups, people like the Boy Scouts, and then just generally non-student groups, the church that wants to rent your facilities. You are permitted under federal case law to give a preference to all of those groups which serve your students. So for example, if you have the Boy Scouts that want to use a room, but then you've also got, a church knitting group that wants to use your room, you are permitted to provide a preference to those groups that serve your students. That's really why we broke it out this way. So that will be a slight change for those of you that have had 3014 in the past. The final thing we did, and then we'll answer your questions, is charging fees for admissions. This is one that has received really mixed reviews, and I've already worked with a couple of boards on this. But basically, the Nebraska Political Subdivision Tort Claims Act has an exemption from liability, meaning the school cannot be held liable if you are allowing folks to use your facilities for recreational purposes and they do not charge a fee for admission. So for example, a common question we get is the Little Kids Wrestling Program. If you allow the Little Kids Wrestling Program to host a tournament at the school and they do not charge a fee for admission, and you do not retain control of those facilities, for example, providing supervision, providing custodial services, that kind of thing, and somebody gets horribly injured at one of those events, the school is actually immune from liability, so long as that group did not charge a fee for admission. It's a crazy little nuance in the Tort Claims Act, but it's one that's important because as you wrestle with these things, no pun intended, I think most of you will allow these groups to come in and charge, for example, a fee for spectators to watch the Little Tykes basketball tournament or the Little Tykes flag football games, because that's how those groups make their money. So it's not the school charging a fee, it's these groups charging a fee. That's the distinction here. So what I suggest is you look through kind of the last section of that policy, which talks about no fees for admission, and just have that discussion with your board. What we put in the policy memo is that you should either make sure that those groups aren't charging a fee or check with your insurance carrier, which many schools, I know many of you that are on this, this webinar have done this. Check with your carrier to make sure that you've got coverage, even if you allow those groups to charge a fee. Because if you allow them to charge a fee, you're still subject to liability for any negligence the school or its employees may have committed. Okay, so that's what took us a couple of months to do here in terms of revising that policy in about a 5-minute overview. Any questions about any of those 4 major changes to that policy? Seeing none, we've got one in chat up there. Somebody.
Oh, somebody chatted. Just so you all know, whoever sent us that chat, and I'll swing over and look at it. We've set up the computer that's hosting this is like far away from us, and so we have to jump up and look before we read your chat. So we'll do that next. I know that facility use is not a sexy topic, but this is absolutely one of the areas that I think that you would be well served to sort of force your board to wrestle with this. Most of you, your school is a de facto community center, and so the community has very specific expectations for what they're going to be able to do at the school. That's a political question, and that's what board members are elected to do, especially those of you that have boards that want to, I don't want to say micromanage, but that want to be active and involved. This is the kind of stuff that's appropriate to push boards to decide. Because what we've seen is when we explain this, especially like the fees section at the end, when we explain that to a superintendent, he or she will say, oh my God, well clearly we don't want to get sued if the bleachers collapse. And so the superintendent just kind of decides on his or her own that that's what they're going to do. And then there's a lot of blowback from the Y basketball or little guy wrestling. I almost got into a shouting match with my brother at Easter one year because he's a little guy wrestling coach, and he was outraged that one of my clients had shut down little guy wrestling making money. So this is one that doesn't look sexy, but if I were a superintendent, I would force my board to talk with each other about what they expect from this policy.
And just so I've worked already, and we've all worked with many boards who have looked at this policy this year. I mean, this is one that we updated several months ago and are including it in the update now. So if you talk to your board about this and they would elect, they've got questions for us, keep in mind all this is part of the service. So give any one of us a call, and then basically, we'd be happy to answer any questions that you or your board have if you want to, for example, start talking about it in June and then keep talking about it or maybe pass the updates at your July meeting. So this is one, like I said, that there are going to probably be some questions from your board, and we're happy to help with those. Okay. No other questions on that. All right. Moving on.
Hey, Bobby.
Oh, yep.
One quick question here. Little kids wrestling tournament, if they're charging a fee at the door for parents, and then if they're charging a fee for the participant to enter the tournament, is one and the same, or?
I think they're probably going to look at that the same way. To be honest with you, I think that was Alan that asked. There is no clear distinction in the law. What it says is a fee either to participate or spectate. So our belief is that, yes, if you're charging, for example, for parents to enter, that's definitely going to account because that is actually their way to get into your building. I think in the event that you can't participate in the little kids wrestling tournament unless your parents sent in $50 a month ago, I think they could also look at that as a fee to participate, because you're not going to let that little kid participate unless the parents have paid that $50 fee. So in that case, I think what you've probably got is a fee in both cases. So if the little guy gets hurt because he slipped on water from the leaky ceiling that we knew about and didn't clean up, that's going to be a problem. Now, at least you're subject to potential negligence liability. Likewise, if the bleachers collapse, or if it's the parent that sleeps on that or that slips on that leaky ceiling, I think in both cases you've charged a fee. So it's not necessarily true that you're automatically going to be liable, but you could literally prevent the entire lawsuit if you didn't allow them to charge a fee. So that's the only reason we bring it up, is I think boards should at least knowingly permit those sorts of things to continue to happen. And that's why I say if your board is going to, and I'm guessing the political pressure on most of you will be a lot, to allow the little kids wrestling and basketball programs to make their money by charging that admission fee either way. Make sure that you've got insurance coverage for those sorts of things. I think most of you will. So most superintendents that I've worked with that have called their carriers said, yeah, you'd be covered for that for somebody, an outside group or an outside program coming in to use your facilities. But just make sure, right? Because if your coverage is something that would exclude that because you could have prevented it by not letting them charge a fee, that's important for your board to know, because you don't want to have to pay us and pay damages for representation, and then if you're successfully sued just because you allowed the little kids wrestling to charge a fee. So there are a host of right answers here, but just make sure that you pick the one that aligns with your board's preference and that you've still got the legal coverage, at least from your insurance.
All right, thank you. Appreciate it.
That,
Instead of charging a fee, if they just had a donation bucket.
Yeah, if they have a donation bucket, Joan, like when you come in, there's a bucket that says suggested donation $5, and Mildred kind of pushes the bucket towards you as you walk in. I get nervous about that. But if it's truly just a pass the hat kind of deal, or just something on a table somewhere that says donations, I do not believe that is charging a fee, and I think we would be 100% able to claim that we are immune under the Recreation Liability Act.
Yeah.
Even if Mildred is shoving the bucket in someone's face, I'm going to argue that we didn't charge a fee. But it just makes me, the more expected it is that everybody pays $10 to get in, the grayer it gets and the harder it is for us to defend.
yeah. And real quick, this is just a crazy nuance in the law. So I apologize if this is confusing, because it has been for even attorneys for years. But if you look at the very last provision of that policy, 3014, under 8C, it says student groups may charge for parking or vehicle entry onto the premises unless otherwise prohibited by the superintendent. There is a specific exemption within this little recreation liability provision, which says charging a fee for them to walk in the door or to wrestle in the tournament, that counts as a fee. But charging them to park does not. So I think what they did in the Unicam rules is understand that we're going to get a lot of pushbacks from schools and those sorts of folks if these little kid wrestling groups can't make their money somewhere. So if you've got the guy sitting out at the entrance to your parking lot wearing a stocking cap in the middle of January because you're having your little kid's wrestling tournament, and that person charges for the vehicle to enter the property, that's okay. That's not a fee. So again, if you've got questions about this and want to talk it over with us individually to reflect your practices, happy to help. We're just raising it because, like I said, it's goofy little provision in the law that has been there, but that we wanted to try to at least give boards the option to capture in this policy. All right. We can come back to more at the end too if you want, if you're thinking through that. But otherwise, we'll keep trucking here for those of you that might have another obligation.
All right, policy 3018, denial of access to school premises. We actually have a great case out of the 8th Circuit that says essentially school officials can keep anyone out of school that they deem to be inappropriate. Obviously, you can't keep them out for unconstitutional reasons because of their race, gender, things like that. But otherwise, you pretty much have complete and total control to keep people out. But what we had in this policy was the very last paragraph is an appeal procedure to the board. And that comes from case law from other states. It doesn't come from a Nebraska case. It doesn't come from our 8th Circuit Federal Court, which covers Nebraska. And so that had been put in there kind of out of an abundance of caution based upon those other cases. Since we haven't had that case in Nebraska and it doesn't apply to us, we've taken it out. Now the board, you discuss this with the board, it's their choice. You can leave it in. There's nothing unlawful about giving them an extra layer of an appeal. It's just not required. Our recommendation would be to take it out, but I mean, that's a board call. The other issue to be aware of is they still may call you, the patrons may call and say, I want to be put on the board agenda. Under our policy, they have no right to be on the agenda, but we have had many people, and basketball seems to be the #1 activity. Grandmothers in basketball. We've kicked out more grandmothers from basketball than any other activity, I think. And they wanted to address the board. If they ask to be put on the agenda, you don't have to put them on. But if they say, hey, I want to talk to the board during public comment, they do have that right. There's not much we can do to prohibit them from doing that. But again, the board just listens, nods their head, says thank you for coming out, and they don't have to do anything else. But so just be aware, you could give them the right to appeal, but you don't have to. But if they want to talk with public comment, they still have that right.
Yeah. And this came up, just so you know, if you look up further in that list, poses a danger to safety and well-being of students. Where I revisited this policy this year was we had a sex offender who was excluded by the school. The superintendent sent that stay away letter that many of you send. And the registered sex offender came and found this policy and said, I would like to appeal to the Board of Education. I don't think your board wants to listen to sex offenders as an agenda item, get to call witnesses and talk about why they're no threat to kids. I think you want the ability to say, no, this stops with the superintendent. So there's one example would be that, the grandma that keeps yelling at the officials and starts swearing. And there's another one of like a registered sex offender. So you're going to get, of course, the potential for an appeal from all different types of folks, but we think this is one where you can stop with the superintendent. So I just throw that out there because we're kind of inspired to relook at this by a sex offender case.
Okay. All right, we'll go to 3038. This is a procurement policy. The U.S. Department of Education made some regulatory changes, and essentially they want more oversight when you're using federal dollars for certain programs. And really, we specifically mention IDEA and Title I, but they have requirements that are pretty much attached to every federal dollar you spend. There's different requirements, especially if you're going to build things, construct things with federal money. But these in particular are from the Department of Ed, and really they just want to make sure that you're giving federal money to responsible vendors. There's a few requirements, as you'll see in there, as to what we do. They're not all that different. Quite honestly, they're the same thing that you would do when awarding a bid under state law. There's actually fewer requirements here than under state law, so it should look relatively familiar. But it's one that's required. It's one that the Nebraska Department of Education, SPED department's been looking at when they come in and review your policies. This is one they're going to want to see. So this one is going to be required. You'll have to put this one in.
What number was that?
3038.
Okay, now it's me again. Staff internet and computer use 4012. And I want to talk about 4012 and 4051 at the same time, because the revisions to these two policies kind of go hand in hand. The unicameral passed LB 821 this last session, and
No.
okay. 821 says that employers are not allowed to require employees to give the employer their username and password to social media. Now, that makes sense to me because, you know, like when you have a little first-year teacher, it's probably not appropriate for you to require her to give you her Facebook password so that you can see all of her, you know, selfies with her fiance. But the problem is with a lot of our school staff use of social media, what's personal and what's employer related is kind of in the middle, right? The coach that runs the, you know, Titan football Twitter account, or the speech coach that on her own Twitter is constantly tweeting pictures of kids at speech tournaments. And so 821 is going to make that, it's kind of going to be difficult for us to figure out how exactly we're going to work with those employees that use basically their personal account for professional purposes. So here's what we did as a policy solution. First off, 4012 has been revised. We had references to social media in the staff internet and computer use, and we took the social media out of that 4012 and put it in its own standalone policy in 4051. So we don't have the crossover like we did before. It's all the social media stuff is stuck over in 4051, and the general staff internet and computer use is in 4012. While we were in 4012, and particularly because we're in election season, we tweaked the wording of the use of school resources for political purposes. The Political Accountability and Disclosure Act simply says that you may not use political resources to advocate for the election of any individual or for the passage of any ballot initiative. Rather than, there has been, in the time that I've been practicing law, probably it's before Bobby was around, so probably 12 years ago, we did have a teacher that actually was fined by the Accountability and Disclosure Commission because she sent an email out to the entire staff lobbying for the election of somebody to the state board. But so we tweaked 4012 to make the language more generic because it was getting too hard and too complicated to try to explain everything. So we told them that they have to comply with the Political Accountability and Disclosure Act and other provisions of state law in 4012. If I were you and I were planning my in-service for 2016-17, I would include just a quick word to staff members about warning them against using school resources for election stuff. In all the in-services I'm going to do for staffs for the beginning of the school year, I'm going to include just a word or two about that issue because I think it's going to be so easy to pass along that Hillary joke or to pass along the Trump meme, and using school resources to do that could be perceived to be political advocacy. And I think as politics gets more toxic, we're going to have more and more complaints about public, and you can just hear like the Platt Institute raising hell because some teacher sent a Trump joke, right? So I would talk to your staff about that, and these revisions to 4012 make the political stuff just kind of more generic. So that's the revision to 4012. We removed social media, and we tweaked the political resources section. 4051, we made some more significant revisions based on LB 821. Basically, we say that if the staff member wants to use the school's mascot, the school's image, the school's name as it's, you know, their Twitter handle, they have to get permission from you. And if it is a school-operated account, if it holds itself out as a representative of the school or a school activity, then that person has to give you the username and password. So if I'm running, and I was a speech coach, so speech always is obvious to me. So if I'm running the Crete High School speech team Twitter account, and it says, you know, CHS speech, that I would be required to give my principal the username and password to that Twitter account. The reason that's important is because then if I get fired as the speech coach, I can't be tweeting out, you know, Cardinals suck and the superintendent is a dirtbag. We did have a staff member that ran a school Twitter account, and they had a bunch of stuff preloaded on Hootsuite, and then that staff member took his own life. And so it was kind of weird that the account was still tweeting like after the death of the staff member, but we didn't have his username and password, so we couldn't get in there and stop it. What this does not allow, though, is for like if, you know, Bobby sends a mixture of tweets that are KSB related, and then every so often he does something personal. If it's a personal account that just teachers are using to talk about work, we can now not require that teacher to give us the username and password to that account. We can still require Bobby to always use good professional judgment. We can take action against Bobby if he tweets obscenities repeatedly, but we can't require him to give us the username and password unless he's running a school authorized account. Again, I don't want to discourage staff from using these resources. I mean, you guys know me, you know that I'm a huge advocate of leveraging social media in an educational context. But this is another one that I'm going to mention to staff members, an issue I'm going to mention to staff members at every in-service. And as you in-service your staff as they start the next school year, I think you should talk to them about this. Last thing, social media and administrators and politics. The charter school debate in Nebraska is a great example of, and I thought school administrators had really thoughtful and useful things to say about that issue on Twitter, you know, and sometimes I wanted to jump in and kind of, you know, get their back. But I think as we are participants in that public policy debate, you need to have a thoughtful conversation with your board about what their expectations are for school administrators in participating in politics, especially if that account is one that is kind of mixed up. You know, if my Twitter handle is KSB high school principal, there's going to be at least some discussion about whether or not what I'm saying is the position of the high school. And again, I think this policy revision is a chance for you to have that conversation. Questions about that? Awesome. Okay. We skipped over in the, if you've got the memo in front of you as you're walking through, we skipped over the revision of policy 4015 because we talked about it when we were talking about the revision to 2005. So that brings us up to 4060.
School vehicle use. This policy came out of a request from the school district. They had coaches and secretaries and other office personnel that were driving school vehicles without students in the car. And they realized they didn't have a policy when one of their patrons said, hey, I don't think that guy has a valid license. And lo and behold, they went and looked and he did not. He didn't transport students, so they really didn't have anything that addressed that person. So that's where this policy came out of. And so I came up with this to address certain standards that might apply to people who would be driving school vehicles without kids in them. And we make very clear in the first section, it only applies to those types of vehicles when you're not transporting kids. We have special NDE rules that apply to other transportation vehicles, so we're not going to worry about those. But here, it does give the ultimate authority to the superintendent or his or her designee to say who can and cannot use a vehicle for any reason, whether it's listed in the policy or not. So we do have the catch-all in that way. It prohibits electronic communication and drugs and alcohol in those vehicles. And it does require them to report any accidents or moving violations or tickets they get. But really the most important part of this policy, if the board wants to adopt it, and the one you really need to look at, is that driver qualification section. I've tried to keep it as specific as I can and then come in with a generic catch-all in each instance so that it catches everything that might come up that we can't specifically address. But I want you to really look at, there's a section that lists the offenses that if somebody commits, number one, if they commit certain offenses, like if they kill somebody with their car, it doesn't matter when that happened, they're never going to be allowed to drive one of our vehicles. If they've had too many DUIs in a certain time period, they're not going to be allowed to drive our vehicles. But you're going to see some blanks in there, and those kind of cover serious offenses, but not as serious as killing somebody with your car. And that lets you go back a certain number of years. You could go back 1 year, you could go back 20 years. But that's something that the board needs to consider as to how far back into a person's driving history do we want to go for these types of offenses. And the other thing is you can add or take away offenses that are listed here if you want to do that. And none of these are magic, and none of these are required. So you can add or take away as you wish. There's also a provision about how many points you've accumulated, again, in a certain period of years. And it's been so long since I've been over at the DMV, I don't remember if it's 10 points or 12 points. If you accumulate 12 points, you lose your license. So we put in there that they've accumulated X points in a certain number of years. You can prohibit them from driving in your vehicle. So again, you'll want to look at that and fill in the blanks. You can make that as restrictive or non-restrictive as you'd like, or you don't even have to have that provision in there. But I tried to cover the biggest offenses and give the board the most flexibility that it could have to make sure that we don't have somebody driving cars that we don't want driving cars. So I guess, are there any questions about that one?
All right, seeing none, and again, we'll just keep trucking here. The next policy up is 5004. So I'll give you a chance to kind of pull that one up, and we're gonna start with the easiest change. So part of the Department of Ed's technical cleanup bill, which, as you know, is often not as technical as they say it is. We had a few substantive changes this year. One of those in particular related to option enrollment and the requirement of adoption of standards where there really hadn't been a requirement of adoption of standards before. So you've always had the requirement of adoption of standards for who gets in when they apply to your school. We'll talk about that in a little bit. We've made some suggested changes to that part of the policy, but what I'm going to start with is the part that is required by LB 1066. So there has always been, in our policy, a provision which says late is late. If you are late applying for a release to option to a different school, we can deny it simply because you're late. Likewise, if you're making an application to our school to come in, we can deny that also simply because you are late. So you have to, if you know that after March 15th, if you have somebody who wants to option out of your school after March 15th, you now have to adopt standards for whether or not you will release that student as a late option student. So in other words, what Brian Halstead told us is that there's no longer a late is late for students optioning out of your school, right? So if you've got that honor roll student who wants to go someplace else their junior year, we used to say, sorry, you're too late. We're not going to grant your release. Now you have to have standards for that. So one of the things we did is put standards into the option enrollment policy, which discuss when a student wants to option out, what the board is going to consider when they get a release request. That did not change, however, the late is late in terms of optioning in. I believe that may be something we'll see in future years now that we've raised that issue, but they're distinct in the statute, the concept of your obligations to adopt standards when somebody's late optioning in versus late wanting to option out. So we've added to this policy those standards, and as you'll see, if you look at section 9, it says things like when the district's already entered into contracts with teaching staff, when the district is already contracted for performance of services, if it's some sort of student that requires an outside contract, or when the release of the student would have a negative financial impact or loss of revenue for the district. We've written this in such a way that we think you're still going to be able to make the argument either way that late is late when that great student wants to leave your school, but now you have to have these standards, so you've got them. Again, we have highlighted the portion which discusses late options in to the school because the LB 1066 didn't change those, but the Department of Education very much now has this on their radar that schools have had this policy which says late is late and we can deny you for that reason. So I think it's just a chance for you to have that conversation with your board. The other changes that we made, we have been going through some discussions with the department, with various schools, in some cases more formalized appeals of option denials. The statute has always said that the board may adopt standards for acceptance of option students. It has then permitted under the law that whole idea of a capacity, right? Like you can set a numeric capacity for how many fifth grade students you want to have, either in terms of the maximum number of fifth graders you want in your fifth grade class, or in terms of the number of option students you'll accept into the fifth grade class, right? So it could be we don't want a fifth grade class any bigger than 50 because we don't want to employ more than 2 or 3 teachers. It could also be that we don't want any more than 2 option students into our fifth grade class for the same reason. Your board also has the ability to declare a program at capacity. So in other words, without stating how many fifth graders we want, we're going to say our fifth grade's full based on these reasons, right? We've got this study which says 20 is an ideal class size, and we don't want any more than 40 students. So what we've done though, and because we think the statute authorizes your board to do so if they want, is to adopt additional standards outside of this pure capacity analysis. And so we've proposed some in the revisions to Policy 5004. And we've made very clear, though, that these are optional. So if you go into Section 4C, or Section 4 generally, you'll see that what we've done is redefine these as numeric capacity, meaning the board's going to say no more than 40 fifth grade students. Programmatic capacity, meaning the board's going to declare fifth grade full because we think that 20 is an ideal class size. We already have 44 resident students, so we don't want to add another option student to that. So, you know, they kind of function the same way, but they might be different, and they're different in the statute, so we divided them out. What we've done is added other standards for acceptance or rejection of option enrollment applications. These are things like if we are required to hire another teacher. We have had in the past something like that in our policy, but we've never really broken it away from the capacity analysis. Now, you may not believe this, but we actually have a tendency to bicker and disagree in our office. This person over here on my left, Karen, is willing to play a little more fast and loose with these other analysis, other factors or other standards analysis.
That will shock you, I know.
This guy over here on my right,
Some of us actually read the statute. So.
this guy over here on my right thinks that we're pretty much limited to what it says in the statute. At least there's one reading of the statute which would say that unless it is because of capacity, you have to accept option students because the statute makes clear what your list of standards can be. So what we've done is highlight this in green because we think it's a point of discussion you should have with your board. There's a good legal argument that says you can adopt standards that have nothing to do with capacity, that might have to do with spending money. The other argument on the other side of it would be that you should not adopt any standards other than capacity because option enrollment is basically our version of charter schools, and the state board thinks this is how we allow students to have choice in Nebraska. To be perfectly honest with you, we've never had, and we've kind of put this in the memo, there was never anything in there about, or that we've never had the Board of Education, State Board of Education, make a determination on standards outside of this capacity analysis. So we wanted to give your board the option to have that discussion. So I'm sure Karen and Steve will have something to add to this, but the only other thing that I'll add is we've also included in the policy updates an option enrollment resolution. The statute specifically says that if you're going to adopt any standards for acceptance of or rejection of option students, it shall be done by resolution. The question that we've had here is whether that means you can pass a policy and that's sufficient, or do you actually have to pass a resolution, which would be separate than a motion, second, roll call vote by your board to pass a policy. So we've included that resolution, and in that resolution, we've included all of the numeric capacity, programmatic capacity, and other standards. So in other words, if you're somebody like this guy on my right who believes that we should do it by the letter of the law, the statute says resolution, so we're going to pass a resolution, we've now included that. Some of your boards may never have had that conversation about what the research says for the best size of a fifth grade classroom or a kindergarten classroom or an 11th grade classroom. So that may be a new topic of conversation if your board wants to go down that path. For others of you, maybe you've already had those discussions and every year you already pass a resolution. That's fine. But without rambling too much further, what we've done is try to kind of make it so that you and your boards have another conversation about option enrollment, because now like I said, we're getting more pushback from the Department of Ed because the state board feels very strongly about how this should look, which we think is probably not always consistent with what the law actually says in terms of their preference versus what the requirements are. So with that, you've got to adopt specific standards for release. You may adopt these other standards, and I think the other conversation to have is whether or not your board wants to pass a resolution which says something like 5th grade capacity is X, or declare certain programs full. For example, if you believe, based on listening to your special ed teachers and principals, that special ed program at the elementary level is full, and your board wants to declare it as such, this would be your chance to do so.
The reason boards don't like to do that, of course, is when the 6'3", 280-pound option kid who needs speech and nothing else, you want to let that kiddo in, and so declaring the entire SPED program full is not. I want you need to think about exactly what that looks like. The only other thing that I want to add to what Bobby said about the resolution is there have been many option appeals using the without a resolution that the school has won. In none of those cases did the people appealing argue that the school board had failed to pass a resolution. We have that case now where it's under submission right now. So we could have an answer to this question about whether or not you have to pass a resolution, and it's very possible that 2 or 3 months from now you'll get an email from us saying, remember that resolution, you have to pass it. And I know some of you on this webinar have been successful in option enrollment appeals without a resolution, and it's your example that we're arguing about in the case that's currently on appeal to the State Board of Ed.
And I would just add, to be clear, I think you can adopt these other standards. And I do strongly encourage you to use the resolution, just because it does cut off that argument that we're having right now. It's wasting the school's time. It's giving them an argument. And my concern is your board could easily pass it, and instead of having to go with a word of an NDE hearing officer, you guys could have cut off that argument and saved some attorney fees and save some time if you had adopted it. But I do understand the political reasons why you do and do not want to adopt the resolutions. But the statute says what it says, and it does say you will adopt a resolution. So it certainly is the safest approach.
I guess the last thing, and then we'll let option enrollment stop.
See what I mean? This is what it's been like in our office. That's why I'm in the middle. I have to separate these two.
It actually has gotten a little bit heated because he's wrong. But we've sent this capacity resolution out for years. And remember back in the day when you got extra state aid for sparsity and extreme sparsity? That's what some schools had adopted a capacity resolution at that point in time. So if you're a school that might have been sparse or extremely sparse, you might go back and look in the bowels of your board's records. You may have a capacity resolution floating around out there that you don't even realize.
Any questions about those? And this is one too where I certainly understand if you're like, wow, everything you just said doesn't make sense. Call any one of us individually too, and we'd be happy to march through what you currently do and then what these other options would be. So again, that's all part of the service. So certainly if you don't, make sure that if you or your board have any questions, you give us a call.
So if there's a student that a school district won't allow to option out because it's after March 15th, and that's what their policy says, does the school district need to go back and re-examine their policy, current policy?
That school district will need to re-examine if they have a provision which says late release is late. They will have to, now, if that happened, hypothetically, if that was a determination made by that school this year or even right now, they could still follow late is late, because the statute won't go into effect until options that you receive during next year, right? I think it's like July 21st, I think, is when that provision goes into effect. So if you receive an application next year around this time as a late option application, that school district could no longer have the late is late. They would have had to adopt specific standards for whether they were going to release a late option application student to option out of their school.
So the kid from Twin River that tried to option into Riverside, Joan, and Twin River said no, late is late. He's not going to get a second bite at the apple for the 16-17 school year. But if he applies late again next year, Twin River will have had to have put reasons into its policy other than late is late. Does that make sense?
Yeah, but under number 9, late applications and requests for release, one of the it says when the district has already entered into contracts with teaching staff. Well, usually that's done by April 1st, so that's really only another 2-week window.
That's true. And this is many schools use late as late. If for no other reason than we don't want a big hemorrhaging of students, on May 1st. There's no doubt that unless the board were to change something in how it processes teacher contract renewals, basically what this does is extend the deadline from March 15th to April 15th, because that's your automatic renewal deadline under the tenure law. So yes, that's true. It doesn't buy them that much more time, at least if your board wants to adopt that specific standard. So
I'm kind of proud of that, Joan, because that was our goal, is to set a new close deadline to March 15th.
And that was I saw that and I'm like, well, problem away. Yeah. Good.
all right, no other questions? We'll keep trucking along.
Yeah, and we are watching the time. We're 90 minutes at most. I mean, so 30 more minutes, and hopefully before then, but we do want to be respectful of your time. Okay, student records. This is one that we all worked on, but I'm really proud of this because I think we have done a really good job of coming up with a solution that works for schools, how they operate, at least how we understand that they operate. So this is policy 5016. If you've got it available, you might pull it up. What I want to really draw your attention to is that this is one of those policies that requires you to make a choice. Now, under FERPA and IDEA, a document, a thing is a student record if it's maintained by the school district. So the question always that we fight about is, what is maintained? Is every single email, every single text message, every single Facebook message that a parent sends, that a teacher opens on a school computer, is that maintained by the school district? And if so, then that has certain implications, and it can become a gigantic pain in the neck, and just even getting a rope around knowing what our stuff is. So we wanted to write a policy that defined maintain for you guys, and that did it in a way that sort of reflected different ways that schools operate. So if option number 1 says that only things on paper are maintained by the school district. So if you have a secretary or a school bookkeeper that still prints every email and puts it into the student file, or prints the final grade report and all that stuff, you can pick option 1, and you're allowed to say, we don't maintain anything digitally, it's all paper.
So when the parent says, I want all of my students' records, it would be limited to what has been printed and put in that folder. That's the important distinction.
Now, the downside of that is if you want to say to a parent, your only student records are the things that are printed and put in the file, that keeps the parent from asking for every email. But that would make your emails public records because they wouldn't be student records anymore. And so the neighbor that hates that parent, that wants to know all the bad stuff their kid did, can now ask for those electronic documents. So it's kind of it's a choice with consequences whether you say it's on paper or not. Option number 2, I think, is probably the option that most of you are going to want to go with, because I think this describes what you actually do. And that says, for purposes of our record keeping, stuff on paper is maintained, and then also the stuff that we keep in our student information system. If you keep all your attendance data and all your grades on PowerSchool, I think it's really hard for us to argue that that's not maintained by the district when that is our, the record that we go to look up whether or not Steve actually graduated high school. So option number 2 says we maintain things on paper and things that are scored in Infinite Campus or PowerSchool or whatever your student information system is. So that's option 2, and I think that's probably describes what most of you do. Option 3 is the other extreme from option number 1. Option number 1 says it's only paper. Option number 3 says it's all maintained. We keep everything, every Google Calendar entry, every email, it's all maintained. And the truth of the matter is, some of you do maintain all that stuff. I mean, now that we've got cloud-based systems in most school districts, we aren't really hectoring teachers to get everything deleted from prior school years. So it may be that we do maintain all of that stuff on the cloud system. Now, this is a dealio where the board gets to pick. Even if a teacher, because you know those fussy teachers that keep everything because they're crazy, the board can still say we only maintain things that are on paper or maintain things that are in Infinite Campus. So this is one where the board can say what they do, even if it doesn't actually describe what your teacher's practices are, if that makes sense. So this is a policy that, again, I think it's a useful discussion to have with your board. The increasing digitization of records is going to be an issue that we have to deal with. And so you do have to choose option 1, option 2, or option 3, but I think they're pretty good options. The other revision that we made is the Nebraska Secretary of State's office says that we have to keep all public records. And their definition of what a public record is super broad, and none of us are complying with it 100% appropriately. So we try to kind of steal second base because we say that no student record will be destroyed unless it is first saved in some sort of digital format. We don't say exactly what that is or how we're going to do it. And then we try to say that we could expunge other records if they're not required to be retained by the Secretary of State. The Secretary of State's not really getting after anybody at this point in time for not keeping everything in electronic format. So we made that revision so that sort of on the face of it, it looks like we're complying with the record retention schedules, even though we think we're probably not.
Yeah, just 2 quick things to add. Number 1, if any of your bookkeepers or business managers came to NASBO and listened to my conversation with them about records, they probably already had that conversation with you about how crazy those retention schedules are. So what this does is it says, the Secretary of State has never formally said that it's okay to save something digitally and not microfilm it, because those retention schedules still tell you to microfilm. But they have said informally to us, we don't want any of your microfilm, right? But so we have always been given the advice by the Secretary of State that if you can retrieve something in a digital format, that is basically an okay status quo for now until we actually change these retention schedules to get rid of microfilming and to instead say something like saved in a retrievable digital format. So what we've done is say the board's going to adopt a policy which says that's what we'll do before we destroy any records. The second thing, having done in-services, what it means to maintain records is absolutely something that should be perfectly clear to your staff. Mm-hmm. So when you're deciding which of these 3 options to pick, think of it in this way. If Steve and I are 2 staff members emailing about a student, option 1 says we've got to print that off before that becomes a student record. Option 2 says we've got to save it in PowerSchool. And option 3 says all Steve or I have to do is save it in our little Karen folder in our email, and then it will be maintained. So think through what your practice is right now and absolutely add training on what it means to maintain records, because if your board selects option 1, or for example, let's say your board selects option 3, and you've got teachers who are deleting those emails and then the ESU cleans them out every 3 or 6 months, you will have violated this. In other words, you will have destroyed a student record without having followed the proper protocols, especially like for a special ed record. So think about adding whatever your board chooses here is going to be important, obviously, for your staff to know precisely what it means. So add that to your in-service training for sure. Okay.
Karen, I have a question. This is Alan.
Yeah.
Just the public records request that you talked about dealing with number 1 versus number 3. What's the difference there, I guess? That's our question as we talk here a little bit. I mean, you said a parent could, if it's not in number 1 where we're not saying we're going to keep that, then the parent could do a public records request on little Sally or Susie or whatever. So how does that change under number 3?
Well, Alan, under the public record statute, I can request any public record, and unless you as the school can say, no, I'm not allowed to release this because it's a student record, then you have to give me what I ask for. So whether or not the nasty email about Steve is maintained tells me whether or not you have to give it to me when I ask under a public records request, or whether you can sort of throw the cloak of the student record over that and say, no, sorry, Karen, we can't give it to you because it's a student record. Now, all the time with parents, I tell staff members that a parent that knows what they're doing is probably going to get this stuff one way or the other. They're either going to get it because they're the parent and they ask for a student record, or they'll get it as a patron when they ask it as a public record. So this is not about keeping stuff out of parents' hands. In fact, my solution is always to give parents everything and we got nothing to hide. The question is, can other people get emails about Steve? And that has come up. I'm surprised at how often that has come up. My kid didn't make National Honor Society. I'm mad. So I want all of the emails about the staff, about every kid that did make National Honor Society, because I'm sure those little groups don't really have true leadership. And so whether or not it's maintained by the school district tells us whether or not you can say no to that patron asking for those other extraneous emails.
So you're recommending number 2, though?
I'm recommending number 2 because I think that kind of straddles that line between stuff that we maintain that we think is important versus just, chitter chatter that could get her passed. Now, it's true in the example I gave you, I could get some emails about Steve through a public records request if you go with number 2. But the stuff that's important, the stuff that questions about whether or not he cheated on the English test, that's probably all going to be maintained under your student information system, which is probably where you want it.
Okay. Well, as you know, I always follow your recommendations, so thank you.
All right, any other questions about that one, or we'll keep moving along here? Okay, so the next one we're going to talk about, and I'm actually going to talk about 2 of them together. Policy 5028, that's initiations and hazing. LB 710 this year came out, and we have always had a hazing criminal law in Nebraska. It has never before applied to anybody other than students attending a post-secondary institution. In other words, this was the frat hazing law prior to this year. LB 710 was enacted, and that changed the definition section of what it means to engage in hazing to include anybody that's doing something like, hey, eat that hot pepper, as a reason to belong to a certain group, right? So now when you've got the senior kids hazing the freshmen on the football team, that is covered by this because it now applies to all K-12 students as well. So what we did in Policy 5028 is we have always had initiations and hazing kind of clumped together because we've kind of been stealing second, right? We took the criminal definition of hazing and we said that for school purposes, prior to this year, it's going to apply to K-12 kids. Now we don't have to do that necessarily because the criminal law says that that already applies to K-12 kids. And that's important for Student Discipline Act purposes, which we'll talk about here in a second. So we've divided out in Policy 5028 the difference between initiations and hazing. Hazing is that list of horribles that you can see, which we've now also added, for example, to the student discipline policy. Initiations would be those things that are done, but that are not necessarily done with the intent of inflicting physical or mental health or safety concerns upon a student, right? So hazing requires you to actually do something potentially dangerous to somebody's physical or mental health or well-being. That's the criminal definition of hazing, so we've just taken that verbatim and called that hazing. Initiations would be other things that are done to gain membership into a group. For example, I had a call from a school who had a gay-straight alliance. And in order to become a member of the gay-straight alliance, you had to write on your forehead, "I'm gay." That was one of their requirements to get into the group. You had to walk around all day with that written on your forehead. Now, that student did it completely willingly. There was no evidence that it endangered the physical or mental health of that student. But it might be that you as administrators want some oversight into what your student groups are doing, even if it doesn't amount to hazing. That's initiation. So that's how we've divided those 2 things out. So 5028 reflects those changes. To save time, I'm going to skip down to Policy 6024. real short version of what we've done here is no other substantive changes to this other than we have included engaging in hazing and engaging in initiations as part of these school rules, which you'll find under the grounds for long-term suspension, expulsion, or mandatory reassignment section. Those are now under sub 11. If you go down to little sub H and little sub I. As you know, the Nebraska Student Discipline Act has the list of 11, 12 things that you can do as a student to subject yourself to long-term suspension or expulsion. That list includes a repeated violation of school rules. It also includes any action which is forbidden by the laws of the state of Nebraska. So we used to only be able to discipline students for hazing if they had done it multiple times because we needed a repeat violation of school rules because it was not prohibited as it pertained to K-12 kids by the laws of the state of Nebraska. So the only other change we made is in sub 11. It says a repeated violation of the following rules or a single violation if the conduct is forbidden by Nebraska law. So in other words, the unicameral, by enacting LB 710, has given you the authority under the Student Discipline Act to discipline students for one single occurrence of something that constitutes hazing. However, if it's initiations, you still need a repeat violation. So that's kind of a tricky little nuance, but we wanted to point out that that's why if you look at the red line versions, you'll see a little change to that sub 11, which used to just say a repeated violation of any of the laws of the state of Nebraska. And then we've changed the definition of initiation, definition of hazing in both policy 5028, which addresses those specifically, and in the student discipline policy. Any questions about those? And if, for example, if any of your principals or any of you are going to attend our student discipline seminar that we're putting on through NCSA, we'll cover that again to make clear now how I think as an administrator you should handle hazing differently than you maybe used to before. So we'll get those folks that are handling those more training on that if they come. But if you've got any questions about those, either ask now or let us know. Okay.
All right, student driving and parking. We used to have, our policy would say that if you drove to school, whether you parked on school grounds or off school grounds, that was based on a 2003 court case. Well, in 2013, the court in Nebraska said, no, they have to be on school grounds in order for you to search their vehicle. And so we changed the handbooks back in 2014. We didn't bother changing our policy, so we've been stealing second base for a couple of years. But the courts made clear that if they drive to school and park off of school grounds, we cannot search their vehicle. And in those cases, if you think they have contraband, you call law enforcement. So we've just revised that policy to reflect that decision from the Nebraska Supreme Court.
Questions? Okay, 5053, the unicameral changed the law, so now like a nurse practitioner or a PA can prescribe an EpiPen or an inhaler. So you're going to have to revise that policy 5053.
All right, 5057, parental involvement in Title I programs. We had worked with NDE last year. I think Bobby had talked to them last year and revised that policy to their satisfaction. As you'll find when they come to do reviews of your policies, these requirements seem to change every year, either from the federal perspective or the state perspective. This is another example of those. They wanted a freestanding provision. We had a provision that addressed this concern, but it was lumped in with other things. They wanted it to be a freestanding provision, so we pulled that out. It had to do with parental involvement programs and then community programs. So we pulled that out and made it a separate entry in the policy. So NDE is now happy. Audio and video, next one, 5063, audio and video recording policy. We've had this policy for several years. We've revised it this year. Number one, we put at the very top so that parents and students are aware you might be recorded at any time while you're on school ground. So that's made very clear. We've added a requirement that the students obtain written permission from administrators before using any recordings from class or other activities. I think this is in essence so that we don't have things appearing on YouTube that shouldn't be on there. And if they do, this will allow us to take actions that we need to take to discipline the kids. And then we've also made clear, this goes with the student records policy that Karen just talked about. If a teacher records a lesson for some reason, we're not maintaining that, or we're not guaranteeing that we're going to maintain that recording for more than a few days, and we're not going to consider it a student record for that reason. It's kind of a transitory record that we're not going to maintain indefinitely, so that they're on notice that if something has happened for some reason during that class and they know it's been recorded, they better be pretty quick in asking for that information.
Yeah, the only other thing I'll add to that real quickly is if your board for some reason wants to go with option 3 in that recording, or in the maintain that Karen talked about in your student record policy, you will have to then think about what it means to have video recording in your school, because it says in there maintain basically in any medium whatsoever. I know from talking with most schools that if you've got security cameras either throughout the building or even placed cameras in certain rooms, usually what happens is once you hit capacity, we're going to kick off the last day before we record the next one. So one of the things to keep in mind is potentially making some point of clarification in there that we're not going to keep every single security video footage segment that we ever record, even though our policy says that any student record is maintained so long as it's anywhere retrievable in any of the district systems. So I don't think there are going to be many schools who are going to go with option 3, but if your board says we're going to keep every single thing and it's going to constitute a student record, we have to think through how, for example, things like video recording or recording basketball games and those sorts of things will play into that.
I have a question at the first paragraph on the audio and video recording. It says the video only be used by students for personal academic purposes and may not be republished without additional written consent from a school administrator. So, for example, we have an info tech class and they do a video as part of their class assignment. Is that saying they can't publish it on Facebook, maybe the class Facebook page, unless I give them written permission?
I think you should probably, Joan, give blanket written permission to the kids in that info tech class at the beginning, like in the teacher's syllabus, that says you can republish any class projects.
Okay. So does this apply for teachers that put it on their school, like our 4th grade teacher has a Facebook 4th grade Riverside. So I have to approve that before she posts any?
I think you should. I don't think there's anything wrong with you saying that that's okay, but like we've had preschool teachers just decide to start recording little kiddos and put it up on their Facebook page, and we've had parents real ticked off about that. So I think you, as the administrator, should kind of have a handle on who's posting recordings of kids and, be able to say, oh yeah, that's fine, no problem. But I don't think it should just be willy-nilly people recording students on school grounds and then publishing it to the internet without you knowing about it.
And if you get a complaint, for example, to a federal agency, they're going to want to know who made the FERPA decision there. Who went through and checked if that constituted a student record or not? Did some of the people in that video, did any of their parents opt out of your directory information? So even though it might not be a perfect system, it at least gives us the argument that everybody came to Joan before posting this, so that we had somebody that we can point to at the school who ran through that FERPA student record analysis as well.
So then a blanket one wouldn't really be appropriate, would it? Because
I think a blanket one to the info tech class, I would probably be okay with, because everybody in that class is going to be creating those documents as part of the project those artifacts as part of the project in the class. I don't think you can just send a blanket thing out to all your staff and say record away. I think you can send a blanket thing out to the staff that says, let me know if you're going to post recordings of students in your classroom so that I can talk with you and make sure that it's okay.
So in what instant would it not be okay?
The special ed field trip to the Henry Dorley Zoo, and we post Here is the resource classroom on a field trip, and parents say, I didn't want my kid identified as a resource kid.
You also have the option to opt out. So most people say directory information includes photographs and videos, but if a parent opts out of that, so you take a video of 10 kids and only one of them's opted out, you can't post that up on Facebook or anywhere else.
Or what we've done is we blur that kid's face out.
Right.
We've actually had that, the pep rally before state, we had to blur the kid's face out that was in the front row because mom and dad had opted out of directory information.
Okay.
Which is kind of funny because then mom and dad were mad because why wasn't my kid in the video?
Yeah. I get that. Okay. Thank you.
Sure.
Bobby or Karen, I have a question on, in your memorandum, it talks, the very first sentence says, students recording teachers and principals for illegitimate purposes. Talk a little bit about that, where students are now videotaping unsuspecting teachers.
Yeah, we have the kid that videotapes the teacher's butt while she bends over the desk to help with somebody else. We had a kid, the principal was yelling at him. I think he had chew, I don't remember. And the kid gets his phone out and is like, you know, in the principal's face recording. And in both those cases, the school didn't have a policy that said it was not okay to record. And so for us to discipline those kids, we had to kind of do some fancy footwork. A policy that says you can't record without teacher permission, once the kid posts a recording of the teacher's butt to Snapchat, you got him because he's violated this policy by recording without the teacher's permission.
Even if he's recording it on his own personal device and not using the school site or the school anything?
That's exactly right, because you have the ability as the school administrator to control what content is recorded within the within your walls. So even if he's using his own phone and his mom and dad's data plan to post that video of the teacher's butt, if it happened in school, you can punish that.
Got it.
Does that also include school vehicles then too?
Yep, school vehicles, school activity, and school grounds.
Okay.
Thank you.
Yep. Grievance procedure, just delete this. Last year, the OCR is pushing towards a universal complaint procedure, which we also like. And so we sent out that universal complaint procedure last year, and this just didn't get deleted. This is like an appendix. So just delete policy 6022 and use your general complaint procedure for 504 complaints.
Okay, we've already talked about 6024. So now 6027 field trips.
Foster parents can sign consent forms for kids to go on field trips. That's all this says.
All right, any questions about those? Okay.
Special education procedures. This is another one that, depending on how the federal government and NDE interprets the rules, these requirements seem to change every year. I think we've revised these every year now for 3 or 4 straight years. Even though there's been no statutory or regulatory change, they keep changing their interpretation. So number one, they did split off Rule 51 and Rule 52 into separate rules. So we've updated some references to the rule numbers. And there was also some substantive changes when they created Rule 52. So we've added some provisions.
And Rule 52 deals with the little guys.
Yeah, the 0 to 3 kids. We added a pre-meeting procedure. This was not required by NDE. This was our own doing. And essentially, this is the whole predetermination issue. And this, because it was a hot topic nationally, we've had it raised in several complaints that were made with the Department of Education here in Nebraska. And that's essentially, teachers have staff meetings. You guys have staff meetings all the time. And you discuss special education kids. Well, the parents were then saying, well, you're predetermining what's going to happen at these IEP meetings when you have these meetings where you exclude parents. So we've made it very clear, these are staff meetings and we're allowed to discuss kids and we're not predetermining anything. We are certainly exploring options, but we're not predetermining anything. So I think that certainly would have been helpful if we would have had that in there this past year for 2 complaints that were made. So we've added that on our own. But otherwise, all of the changes have been made to address concerns that have been raised by NDE or certain rule changes that were made because they split Rule 51 off into Rule 51 and 52.
Any questions about the special ed procedures? Okay, real quickly, we've got a provision in the memo about LB 876. Basically, this allows your board to vote like the unicameral votes now. So long as you've got a big display somewhere that any member of the public attending the meeting can see, your board is permitted to cast their votes electronically, and that will constitute having taken a roll call vote as required by the Open Meetings Act. So you've never been able to do yay or nay votes. So if you're doing that, you shouldn't. But if you have been doing yay or nay votes instead of roll call votes, this is sort of your chance to use it as a reason to correct your practice. Basically, roll call votes are still required, but you can now do it in an electronic format so long as members of the public attending the meeting can see the result of the vote. So we did not think that we needed to necessarily add this to a policy because basically it's just another option for your board to take a roll call vote. But if you've got a policy which says, for example, there shall be a roll call vote read by the secretary of the board, you might look at changing that or taking that out and just say we'll do roll call votes, because then you could either do it by the secretary calling the roll or by the electronic method. So we didn't change any of our policies like the early 2000 series policies which deal with board governance to add this in there, because we've always just said we'll take a roll call vote however that's permitted by law. But if your board's going to do this, think through practically how that's going to look, because this law had, like I said, those specific requirements about making sure members of the public could see the result of the vote.
Energy financing contracts. Okay, these are contracts. It was a great idea when it was implemented. I don't like the way they've been implemented. I hate these things. But essentially the idea is you're going to replace old outdated equipment with new equipment. That's going to save you a bunch of money on energy costs, and that savings is supposed to pay for the changes that you've made. Quite honestly, in my experience, the costs under these projects are inflated, and I think any savings you would have had goes to the energy companies, but that's a whole other political issue. I'd be happy to talk to you about it if you're going to go this way. But really, they've made three basic changes. One, they've added water conservation and wastewater projects to the list of projects you can use with energy financing contracts. They have removed indoor air quality from the list of projects. This is probably the biggest one that impacts schools and freaked out a couple of schools that were in the midst of this because this had an emergency clause in it. And so what a lot of these companies were doing, these energy companies, were getting people to use the energy financing contracts. They would use QC Puff money to do the projects. That's been removed. So you can't do your HVAC projects under here except under very limited circumstances that aren't going to apply to most schools. So those are out. And then they've also reduced the amount of the QC Puff levy from 5.2 cents to 3 cents. If you already have one of these projects where you issued bonds to support the project, you're not going to be affected. This was only moving forward. It doesn't go backwards. So if you've been issuing bonds or got it in under the deadline, you'll be fine. But those were the biggest changes out of those two bills.
Okay, so what all that leaves left for us, we've got 2 minutes to cover transgenders, so that should be easy. Well, what we'll do here is maybe just stop and see if anybody has any questions about any of the first stuff we've talked about, and then give you the option, if you want to, of sticking around to hear us just do a quick 1 minute. I'll do a quick 1 minute thing on activity participation, and then maybe we can just take your questions as it relates to transgender students. We've put all of our thoughts in the memo. We didn't write a policy on purpose because, as I'll kind of explain here in a second, we think that your existing policies are sufficient if your board doesn't want to do anything right now. So that way, anybody that has to take off that has already had this conversation with their board, you can, or if you want to come back and listen later, you can. But obviously, you've all received the guidance from the federal government that says you should make all decisions based on the student's choice of their gender identity or how they identify as an individual student. That is, of course, something that the governor and the attorney general don't agree with. And so what you've got is nothing new. We've had these disagreements that have been occurring in Nebraska and across the country for at least 5 years now. We started talking about this stuff. So if you've never adopted a policy with specifically targeting transgender students or changing, for example, your non-discrimination policy as it relates to transgender students, we do not believe legally, and I think we've got a winning argument for sure, that you have not done anything wrong by not addressing this issue in policy, either specifically or changing one of your general non-discrimination policies. The whole basis of the federal government's guidance is that your Title IX and other prohibitions against sex discrimination also include discrimination against gender. It's like sex is the main word, but a subset of that word is gender. In other words, their argument from a legal enforcement standpoint is that you don't even have to include gender in your policy in order to be required to accommodate a student who has a different gender identity than what's on their birth certificate. So for that reason, if the federal government says interpretation of the word sex is good enough to basically rewrite the law, then why don't you as a school take the position that how you interpret your anti-sex discrimination policy is actually consistent with their approach? For that reason, we have suggested to anybody that's called us and asked for our recommendation, your board should just continue to follow your sex discrimination policy with the understanding that regardless of whether you agree with the federal government or the Attorney General that this is crazy and that we should ignore it, you can do either of those things if your board feels that passionate by how you interpret your sex discrimination policy.
And I want to jump in here and just, look, I don't care. I feel great empathy for these kids. I have no political axe to grind. But I think it is really a bad idea for school boards to wade into political controversies if they don't have to, right? When you catch the cheerleaders getting drunk on a field trip, you have to act and somebody's going to be mad at you. Why make enemies over this transgender issue if you don't have to? I just feel really strongly that we are giving boards the impression that they have to do something that will make them enemies no matter what they do, and they don't have to. Doing nothing is a perfectly legitimate choice. In fact, in that GG case, which is the case in Virginia where the kid is suing because a biologically female student who identifies as male wants to use the men's bathrooms, what they used against the school board to prove that they were basically a bunch of bigots was comments made by patrons at a board meeting during public comment. So if, for example, the Milford board just has a discussion about the issue of transgendered, and Bubba over here, who's a patron of Milford, shows up and says, really rude and hurtful things, some ACLU lawyer is going to use that against the Milford board. So I just think, I wish all these politicians, if they want to have a fight about the rights of transgendered kids, they should go right ahead. But forcing schools to be part of that conversation, I think is not good for schools. And I just feel like it diverts us from, it forces us into doing stuff that doesn't really change student learning and student achievement in the vast, vast majority of situations. Now, it's true that if the Office for Civil Rights comes in and does an audit or is dealing with a complaint about a transgendered student in your school, OCR is going to tell you that you have to change your policies. And we can fight about that when OCR shows up. But here's the truth, guys. OCR always makes you change something. So I don't think that puts you in any worse of an enforcement position than you are if you do what the ACLU or the Department of Justice says and tells you to adopt a policy that says, kids can do whatever they want based on their gender identity. So it's not that I have a political axe to grind. I care about schools. I care about you guys only picking fights that you have to have. And I think this is one that kicking the can down the road is still a perfectly valid and legitimate choice.
There are other schools who are litigating these issues right now because their boards have said, for example, every decision that we make here is going to be consistent with the birth certificate. The ACLU is now going and finding those schools and suing them one by one on purpose.
And if you want us to defend that lawsuit, we'd love it. But I'm not sure that's a great use of your resources.
Mm-hmm. The other two quick things to add to that, and then we'll take any questions that you guys have on this issue. Number one, check your current policies.
Yes.
Check them. If you, for example, haven't been receiving our policy and handbooks for the last several years, check your policies that talk about non-discrimination in your handbook provisions, both staff and student, and all staff, student, and activity handbooks, any other handbooks you have, and see if they have included the word gender. For a while there was no distinction when the feds talked about it, when the governor talked about it, when lawyers talked about it, between sex and gender. Right? Everybody used those two terms interchangeably. Of course, now those are not interchangeable terms and they mean significantly different things from a legal perspective. So you may have, for example, had in your non-discrimination race, color, creed, sex, gender, whatever else. If you've got gender in your policy right now, you've done what the federal government wants you to do. So
Without even realizing.
So keep in mind then that your board, if they get a request from a transgender student to use the opposite bathroom, will now be subject to an OCR complaint where the OCR's got a pretty good argument that not only has your board violated federal law, they violated your policy. So especially if you've got a board who is inclined not to include gender, who is inclined to say we're going to use bathrooms and locker rooms based on biological sex, make sure that you don't have the word gender in your policy. If you do, call us and talk through the options that you've got about either removing that or changing the policy in some way. The other thing, the last thing here, if you are going to be building or remodeling, I think you should give us a call. There are a lot of federal school law attorneys throughout the country, especially on the East and West Coast, that are very deliberately advising their schools. If you're going to be building in the next, 6 months to 6 years, you ought to think about the trajectory of this issue and how you might want to address it while you're building or while you're remodeling. That's not to say that our advice is going to be, yes, make sure you have individualized stalls in every facility, but it's to say that we think you should have that conversation with us and then with your board.
And your contractor to see how many dollars we're talking.
Right. The very last thing before we open it up to questions, activity participation. The NSAA's policy is in effect right now, and that's the one that says students apply to their school. If I am a biologically male student and I want to play volleyball this coming fall, I am required to apply to my local school for the ability to play consistent with my gender identity. I don't go right to the NSAA. The school then, either the superintendent or a principal or maybe an activities director or maybe even your board, is going to receive this application from the biologically male student. Your board is going to have to make a decision, whether that's to decide one way or another how to handle that application or to make you as the administrators decide. But basically, you've got two choices. Choice number one is to tell that student no. The NSA policy makes clear that much like other eligibility determinations, for example, whether that foreign exchange student that comes in its semester is eligible, that starts at the district level, right? You petition the NSAA for that student's eligibility. Same thing with transgender students or students that want to participate consistent with their gender identity. That application comes to the school, does not go to the NSAA. So you're going to have to decide, are you as a school going to say no, which is an option your board has, but again is potentially going to subject you to some liability in terms of now that student can file a lawsuit with the ACLU against the school for denying their ability to participate consistent with their gender identity. The NSAA gets off the hook. Mm-hmm. The other alternative is that your board can say, we already send any application for eligibility up to the NSAA just as a matter of course, because they've got mechanisms in place to decide whether that student's eligible. And we don't want to forfeit all of our games this year by playing ineligible students. So we're just going to send all of those up to the NSAA. That is also a decision your board could make. So even if your board is not inclined to allow biologically male students to play volleyball, they should think about what it means to deny that application at the district level versus sending it up to the NSAA.
And the way the NSAA policy is written, pretty much any kid that applies to play sports for the gender that's different than their biological sex, the NSAA, the way that process is ultimately going to work, it's probably going to be they say no. So your board saying, yeah, we're going to pass Bobby along to the NSAA and let him ask if he can play volleyball, that lets the NSAA do the heavy lifting and tell Bobby no. And then we're not a defendant. I mean, although I think we'd probably still be a defendant in a lawsuit, we're not the triggering mechanism to be the defendant in a lawsuit. Mm-hmm. And then when parents show up and they're outraged that we passed Bobby on to NSAA, we can say, we pass everybody on and then the NSAA decides. I think that's your least deciding decision, if you know what I'm saying. That keeps the most of your options open to say, we're going to pass everybody on to the NSAA. Mm-hmm. Now, y'all know that I like Rex. I think he's a great lawyer. I think Rex does a great job. I don't think the Department of Justice is going to say that the NSAA policy passes muster. I don't think they're going to say it goes far enough either. So I don't think we're done with this issue as far as the NSAA is concerned. And so I think we'll have to revisit it at some point in time, but we're here now, and so that's what where we're kind of at.
Yeah. So in general, we think your policies as written are fine as long as they prohibit sex discrimination. The one decision that you're going to have to make either at the board level or by directive down to the administration is what to do with these NSAA applications.
And I think you should encourage your board members that watch a lot of Fox News or a lot of MSNBC to not make a national statement in, Bruning or wherever you are. I just, that's, I think, our biggest battle.
Any questions about those? Just as a caveat, if your board wants to make that statement, we'll help you.
Yeah.
And we won't charge you for it because it's part of the policy service. So that's, I got a call from an administrator who I don't think is on this, and he said, no, my board's going to want to pass that policy. And I said, well, then give me a call and let's talk about it. So with that said, any questions about maybe what your board's thinking, anything we can help with at this point?
Wow.
None.
That's why we put transgender at the end, so you'd be tired and wouldn't yell at us.
Well, if you want to have any of these conversations about this with any of us individually, just give us a call. We talk about these issues a lot here, so we'd all be happy to talk to you about them and whatever your board might want to do.
Okay, 3 more things and we'll be done. 1, we will post a video of this to the website, so since it was so fascinating the first time, I know you'll want to watch it again. And it'll be under the policy page, the link that Sherry sent out in that first email. 2, we really want to make this useful. So if this format works or doesn't work, or if you're sitting here thinking the whole time, God, I wish they would blah, 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 please let us know, because, our goal is to make this a useful and utilitarian exercise, so we crave your feedback on that. 3, Joan Carraher has, while we've been talking, pointed out that there's a sentence fragment in policy 2005. Joan, you're absolutely right. It doesn't make sense. We're going to fix that, and we will repost it on the website and mail it out to all y'all. I don't think it's going to matter substantively, but it's sloppy work. I just, we want to fix stuff as we find it. So we'll get that fixed up and re-emailed out to everybody. I got one quick question here, Mark. Sorry if I missed this earlier. Video includes uploading football video to Huddle. That's a good question. If you go with option 2, I don't think it does.
Mm-hmm.
It would not be prohibited under the recording policy as we've written it, because it would be with consent.
Right.
So I think you'd be okay unless you go with option 3 for your student records policy.
Well, I suppose the question would be who, so if the assumption is the student is taking so for example, we've got the student manager who's recording the football game. The student asks for a copy of the football game, edits and cuts, and then sends that video, or just sends the entire film to Huddle.
The way it works now is the Huddle, like Eli has film, his film is on Huddle, and it's all his plays. So the school is uploading that film.
Mm-hmm. Which I think is probably okay.
I think that's okay. But I think if you go to option 3, you're going to have to, it wouldn't matter because it wouldn't be on a school district server, it'd be cloud-based and we wouldn't have control. Mark, I think you're okay to go ahead and have them, obviously you're okay to go ahead and have them continue using Huddle. I don't think that would fall within the definition of maintain, and I don't think it would violate the prohibition against recording. If you go with option 3, I think you're okay either way, as I think through it. That's a great question, though. Email. Questions?
Any other questions?
It's been the best Wednesday morning of your lives, or what?
Thanks, guys.
Thank you.
Thanks, everybody.
Thank you.
Thank you.